Hello, everybody, and welcome to Can't Buy My Silence's NDA training session for employers and organizations. My name is Julie Macfarlane, and I am the founder of Can't Buy My Silence Canada and a professor emeritus, distinguished professor of law.
And my name is Dr. Angela Grace. I am a registered psychologist in Western Canada. And I am here working with Julie on NDA Informed Training because I believe that it is really important to understand the trauma that endures from signing NDAs, and together we can make a difference.
Thanks, Angela. So let me just first of all, I know this is virtual, but I am in the Caldwell First Nations um, ancestral lands. And I just want to begin by saying that we do, of course, honor the original inhabitants of this area and thank them for being able to live in this beautiful place. So here's a little overview of what we're going to do in this recorded session. We're going to say a little bit about the campaign to restrict the misuse of non-disclosure agreements by legislation. And then we're going to say a little bit more about how these come up, where they manifest themselves in many, many employers and organizational policies. Because part of what we want to be able to do today is to help you to recognize what a non-disclosure agreement looks like if you are committed to removing your organization's reliance upon them. And we will talk about alternatives and how to spot them. We're then going to do a little bit more on what I often call Law 101. I'm going to give you the background to how non-disclosure agreements operate as legal contracts, because that's the area of law involved here. And let me just underscore that the whole idea of this is to show you how they work in a way that will be completely accessible and clear to you. There's a lot of misinformation out there. And sometimes there's talk about how, oh, this is all very legal and complicated, you wouldn't understand. But I'm here to tell you it really isn't that complicated. And we're going to make it clear to you today in this recording. After that, we're going to hand over to Angela, who's going to talk more about the trauma impacts of non-disclosure agreements and to relate this to her own work and her own experiences. And then we're going to end with a short piece on what might the next steps be for your organization or institution. Obviously, since this is being recorded, we can't take your immediate questions, but we will show you a slide at the end where you can address further questions. And there's also a great deal of information on our website, can'tbuymysilence.com. So here, first of all, are our campaign goals. We began by trying to raise public awareness of non-disclosure agreements because what we have learned is that they have become almost default, almost an always in many, many kinds of agreements that are being made to settle matters that have raised, let's call them embarrassing and reputation potentially damaging issues for employers. So we wanted to raise public awareness about how often when they signed off and settled a complaint, for example, about sexual harassment or sexual abuse or any form of discrimination, that they were also almost always being asked to sign a non-disclosure agreement. So the first part of this campaign has really been just making people more aware and also to provide people who signed NDAs or perhaps have been through an experience when they've pushed back and resisted signing an NDA. We wanted to give those folks a place to tell their story, both because that has its own cathartic benefits to them since they are otherwise banned from talking about what happened to them, and also because other people could read these stories and would realize that they weren't alone in their experience. In fact, as you're going to see, there are an enormous number of people who've been affected by signing a non-disclosure agreement, usually without fully understanding what it was they signed. We have been using voluntary pledges with universities, with churches, and with unions to try to encourage organizations to take this step of saying they won't use NDAs any longer and they will remove them from their policies before legislation. Because legislation is our end goal, and that's what will finally protect people from having NDAs put into these settlements and finding themselves permanently silenced. But in the lead up to legislative reform, there's nothing to stop an organization like your own taking a pledge, and many organizations have already done this, including some really huge ones like Google and Salesforce, to no longer continue to use non-disclosure agreements, if you like, anticipating that they are very soon going to be legislated as unenforceable and not fair to use against people. So what is an NDA? The first point is it's a contractual agreement, or it's a clause in an agreement. And in that agreement, there will be something in which one or more parties will have agreed not to disclose material or knowledge designated as confidential to any third parties. In other words, to anybody but the people who are signing this agreement. And in a minute, I'm going to show you an example of what this might look like. But something that you should know right away is that these days, it's unlikely it's actually going to be labeled as a non-disclosure agreement. It used to be much more straightforward for people to be able to find these in their agreements because they were described as non-disclosure agreements. But as that has become more and more toxic and more people are aware of NDAs and the harm that they do, they're now almost never described this way. They're usually, the word you're looking for is confidential. Anything in relation to confidentiality. And it's not different from an NDA. It's whatever you're being told you cannot talk about. And one of the reasons this is so important that you see clearly what you're being told you can't talk about, or as an employer, what you're saying to people you cannot talk about, is that it's an obligation that lasts forever. So if you have signed an NDA, or if you as an employer have asked an employee to sign an NDA, the expectation is that it will be lifelong. So Angela will speak more about this in a few minutes, but that means that this obligation hangs around people's necks for their whole lives. And because this is a contract, and when two parties make a contract and one side breaks the contract, then there are always penalties for that breach. And so technically, if you break an NDA, or if your employee breaks an NDA, or if you as an employer break an NDA by speaking publicly in a way that identifies the parties and describe, if you were to describe your own experience, if you're the complainant party, you are in danger of being sued for breach. And we do have examples as recently as this March this year of people being sued for simply posting something saying, my complaint with my employer has been settled. That's also deemed to be a breach of an NDA, because if you've signed one, you can't even say that you've signed one. Just think about that. This is why these are so incredibly watertight and constraining on people. And I've also seen many NDAs now that include further penalties on top of returning any compensation, penalties for breach, such as $500 for every Facebook post or every Instagram post, because the real fear here is that this information that might be damaging to one party, to the employer, to the institution, is going to be out there on social media, and then everybody will know. So, if you see this as a logical consequence of the reach of social media, then you're understanding basically what's happening here. But it is a very strict obligation. And it does mean that people are prevented from speaking about what has happened to them. And I think increasingly employers are starting to realize that this isn't good for their workplace going forward. Um, Fewer and fewer people will make complaints at all. They will not be able to resolve matters that might be systemic to the organization or toxic. And that simply doing away with silencing people we are seeing now does not lead to some kind of outburst of information on social media. Quite to the contrary. If people are released, what almost always happens is nothing happens. They don't say anything, they go on with their lives, but at least they can talk to their family and friends about the experience that they had. So if you're an employer who is worried that if you were no longer to use an NDA, everybody would be writing bad things about you on social media, that really isn't what the research shows. The research shows that once people are released and they can talk to a therapist, they can talk to family members, they don't need to be out there putting it all over social media.
I can actually personally attest to that as well. I mean, the release from my um, legal process was almost 2 years ago. And I've been processing it myself and with Julie and with the people in my life and have not had any inclination to put it on social media because I'm very intentional about who is worthy of hearing this deeply vulnerable and personal information. And we all know that social media is not the place for that. So that's part of the processing of trauma is encouraging people to be very intentional on who they choose to share with. But the act of being able to share freely without the non-disclosure agreement is very important.
Thanks, Angela. And, just to reinforce that point, the president of UPEI, which of course was Prince Edward Island is the first place in Canada to have passed law to restrict the use of non-disclosure agreements. Um, the president of UPI and also the president of one of our union supporters have both made the point that after you take away the possibility of an NDA, people actually find it so much easier to make a bargain because they are less angry. And they're less angry because they are not being constrained in this way from ever speaking to anybody. And exactly the same, there's been no outbursts on social media in those instances either. So I often think it's useful to understand how something started in order to really understand how we got here. And I think the history of NDAs is very instructive and it's very simple and uncontended. Um, Non-disclosure agreements, these contractual agreements for secrecy that would last forever, were originally developed in the 1970s in California, where, of course, there was a whole outpouring of new technological developments in terms of platforms and softwares and so forth. And in the process, obviously, companies were beginning to protect these ideas, these new designs with intellectual property, so a patent or a trademark, because they were that this was information which they owned, given that they had employed the people who created it. But that takes time. Getting something patented or trademarked, if any of you have ever been through that process, it does take a while. And so in the meantime, they were vulnerable to people taking information from one company when they went to join a new one and sharing those still unprotected in development ideas. So that was the reason for NDAs. And that actually seemed to make a certain amount of sense because this was a particular period in history where something was needed to protect these pieces of proprietary information. And of course, we've always seen some version of a non-disclosure agreement used where someone works with confidential client material because they have obligations not to share that with others. And that as well is quite different. So what we're trying to do in our campaign has got nothing to do with these first 2 points. Those things can still continue. What we've seen, though, in the last 10 to 15 years is what we call the creep, which is that non-disclosure agreements have now been seen as a great way to cover up and hide not unprotected trade secrets, but misconduct and any kind of embarrassing allegations that might affect the reputation of the organization. But what we're seeing is that efforts to cover it up are often worse for the organization than simply being upfront. So, numbers. We know from 5 different studies now that in their working lives, 1 in 3 workers will sign an NDA. And what's important to note about this particular piece of data, this statistic, is that the studies that we have done and have been done in the US and the UK show that NDAs are used far more frequently, disproportionately, in low-income precarious employment. So let me just put it this way. If you're stacking the shelves at Walmart, which would be a classic example, and you've been asked to sign an NDA, it's not because you're leaving and taking trade secrets. It's because they don't want that person to talk about being sexually harassed or perhaps being subject to discrimination. So this is the way that they have been repurposed, disproportionately amongst low-income workers and disproportionately against women. Far more women than men sign NDAs, probably because they're used pretty much as a default in sexual harassment, which isn't always against women, but it's often, and because they're often used in pregnancy and maternity disputes where the employer is trying to pay less or give less than the statutory benefit. Very high numbers of women who are either NDA'd in their pregnancy leaves or their NDA during their maternity period, so they do not get their full benefits. And the other group that we have seen huge numbers with are racialized workers, people of color, and that includes Indigenous people. Because if somebody is complaining within your organization of racism or anti-Indigenous racism, that's something that instinctively employers want to hide. Now, of course, the reality is people will talk. And, we know that, as I've already said, that this is something that tends to taint organizations once they have been exposed as using non-disclosure agreements. Classic example being Hockey Canada, when all of that came out in 2022, and people saw that this was an organization that had been using non-disclosure agreements to prevent victims of sexual assault, which they paid out money for by hockey players, from speaking about what happened. So I think that the only thing worse now for an organization than using NDAs is being found out to have used NDAs. And so it isn't really working quite so well any longer to say, we'll just silence all of that and push it under the rug. And employment lawyers, who are mostly the people who deal with NDAs because of when they're used in the legal process and how, they estimate that an NDA is part of a standard release, that is the document that is the settlement for a grievance in the workplace or between an employer and employee, or an agreement between a victim and somebody who they say has sexually assaulted them. 95% of these now include non-disclosure agreements, which was what Angela experienced when she went through her own process for settling a case, and it was what I experienced when I went through my process for settling a case for historic sexual abuse, that they are simply expected of people who are making those settlements. And that's what we're trying to stop. So where do they come up? First of all, we're seeing non-disclosure agreements in employment contracts. So in other words, when people are first hired. And again, I would encourage you to look at what goes into your standard contract of employment, because it may have been there for a long time and you haven't particularly thought about it or looked at it. But we see what I call preemptive NDAs frequently in contracts of employment. So what you're being told to agree to when you sign your contract is that even if you are subject to and experience some misconduct in the future in this workplace, you are already agreeing that you won't speak about it. The United States federal government has now passed legislation saying that employers cannot have preemptive NDAs in employment contracts if they're trying to prevent complaints of sexual harassment, and hopefully that will be broader soon. The beginning of the process then of employment is where we sometimes see them, but also we see them in letters of severance. This has been much more recent, that in standard letters of severance, even if there has been no dispute at all, those letters of severance will say, nothing is to be said in the future about any misconduct that you might have experienced. And they frequently include something called a non-disparagement clause, which I'll show you an example of in a moment, which says you can't say anything that might negatively affect the reputation of your employer. If you think about that, that's pretty broad, and I'm going to come back to that in a minute. And then the third box here is the most frequent place where we originally saw NDAs, and still do, which is to make a settlement to a complaint that is being brought by an employee or some type of civil lawsuit that includes discrimination or harassment or assault, for the same reason, to keep it secret. The other place we use them, and again, I would encourage you to look, they're being used, and I'd encourage you to look at your policies, is that if you have a process in your workplace, in your institution, for an investigation of a complaint or a mediation around a complaint that's been brought, we're also now seeing non-disclosure agreements being asked for at the beginning of those processes, part of the terms of investigation or the terms of mediation. Now, I was an employment mediator for about 30 years, and what has always been used is a clause that says, for the time that we're mediating, or for the time that we're investigating, we're going to try to respect a cone of silence. There won't be social media. People will keep their discussions private in the hope of really encouraging a frank and open discussion. But what these now say is, no matter what happens in the investigation, if the investigation upholds or denies the complaint, or if there is or isn't a settlement in mediation, you still can't talk about it ever again, which obviously makes no sense because you're just at the very beginning of the process. And we know that this is leading some people in some organizations to bring a complaint, refuse to sign a non-disclosure agreement before they do a mediation or an investigation. And then, as you can imagine, the whole process collapses. So again, this is something that we feel it's very important that employers don't require of people. If you genuinely want to resolve this, use a time-limited clause that will make the period of the investigation or the mediation a private one, but not one that lasts forever, which makes no sense at all for the complainant. So let's have a look at them. The top piece here is an example of a classic non-disclosure agreement. The parties confirm that they agree to keep the existence and the terms of this agreement confidential, and the circumstances concerning the termination of your employment confidential. Now, that's a pretty typical one. We sometimes see it simply shorter than that, simply the existence and terms of the agreement confidential. And sometimes people try to argue, well, that means you can still talk about your experience. That's not a problem. But if you actually think about it in practical terms, and we have both of us experienced this and have met many, many other people who've experienced this, if you can't say that you've made a settlement, if you can't say, yes, they compensated me, maybe you don't say the number, but if you can't say what the outcome was, you can't talk about your experience. It becomes this sort of very porous between what's in the agreement and how can you talk about your experience without talking about what's in the agreement. And so those are also clauses non-disclosure agreements that keep people very, very afraid of speaking. And I just want to raise that because increasingly we're seeing this very shortened version existence in terms of the agreement, confidential, but in practice, it has just as much impact on people being very, very anxious that they don't want to break it and feeling that they are continued to be silenced. And then I said I was going to give you an example of a non-disparagement clause, and that's the second example here. The employee shall not make any adverse or derogatory comment about the employer, their officers or employees, and the employee should not do anything that shall or may bring the employer or their officers, employees, etc., into disrepute. So what the non-disparagement clause does, and we see this very frequently in letters of severance now, as well as in settlement agreements, is it says that even if you don't actually reveal anything about what happened to you, even if you don't reveal anything about the terms or the existence of this agreement, you can still be in breach of it if you said something which the employer considers will bring them into disrepute. It says shall or may. So in other words, this is an incredibly broad standard. We have a defamation law in Canada which says that if you say something publicly about someone that's untrue, you can be sued. But this refers to something that might be true if it still brings the employer into disrepute. So in some ways, I call non-disparagement clauses the evil cousins of NDAs because in some ways they're even worse. So I would strongly advise you to look through your policies and your templates to see whether or not you have anything of this nature. Why are employers using NDAs? We've already said to protect the reputation of the business or organization, but we would cast some doubt on this because, as we've said, what generally happens after NDAs have been removed is that people are much less angry and there is no social media outburst. And of course, there's always a risk that there might be when people are angry. But there are other reasons as well that I want to be clear about because this might be something that's relevant for you as an employer. It's a habit. These clauses have been in your policies, if they're in your policies, probably for at least 10 years. And your lawyers believe, as a matter of habit, that these are important to protect your reputation. And there hasn't really been an adjustment in light of the harm that they do to people, or the fact that, in fact, they make people so angry that they're probably counterproductive in any case. Something else I've found a lot, and I know Angela has too, is that a lot of times employers are really, and lawyers as well as employers, so lawyers who work within your organization, perhaps having done this for so many years as a matter of habit, they're often really unaware of just what the consequences are for survivors. The trauma impacts, which Angela is going to talk about in a moment, they can't even go to a new prospective employer if they want to start in a new place. And more than half of people who sign a non-disclosure agreement then leave the workplace. They just feel so isolated and sort of unappreciated, and they've had a really difficult experience. Those people can't tell a prospective new employer why they left the old place. So they have a resume gap. And the other thing that we know from our research is that many people decide not to bring a complaint at all because they know they're going to be asked to sign an NDA. And that's not good for your workplace either. And of course, there is the inevitable temptation of kicking the can down the road. But we are suggesting to you that you seize this opportunity to make this right, to stop using NDAs, which are not helpful when it comes to reputation, and certainly are not going to be something that, if it ever came out, would be good for your organization. Consequences, I've already talked about a little bit. This expression, pass the trash, is an expression that actually came originally out of school boards. School boards use non-disclosure agreements all the time to send teachers who have been who behave badly with students, secretly take pass them to another school board. It's outrageous, but it happens all the time. And that pass the trash expression is one that has come out of the research that's been done specifically around school boards and their use of NDAs. I
We
think
can
it's,
also look at the same thing happening in large religious organizations where clergy who behaved badly were put on temporary leave or passed to a different diocese. So it's the same thing of avoiding transparency and accountability within the larger organization itself.
yes, exactly. It allows someone who's behaved abusively and sometimes possibly criminally, because, depending upon what the misconduct is, it might rise to the level of a criminal complaint, which, by the way, is not affected in any way by that NDA. There is always the right to report to police, regardless of an NDA. So that's another problem for employers who think that they've managed to dampen it all down. That person can still go to the police. And it creates, and there's more and more work on this now, a toxic workplace because it chills the climate for people reporting, as I've already said. In our study currently, 1/3 of people say they didn't make a formal complaint about misconduct because they anticipated signing an NDA and they weren't prepared to. So, all of the work that we've done around trying to encourage people who are the victims of sexual harassment, the victims of discrimination, and so forth, to step forward and have that dealt with in the way that it should be within a workplace, have it properly investigated, have it properly addressed if it's made out. All of that is just getting shoved underground again. And that is even without the trauma impacts on the victims themselves, which is where we're going to move to now. Angela, over to you.
So now we're going to talk about the trauma impacts of signing NDAs. So let's begin with a myth in that survivors are not impacted by signing NDAs. Well, the fact is, signing an NDA has numerous impacts, including negative mental and physical health effects, social isolation, and economic and employment harm. NDA misuse also promotes a culture of silence around violence and protects the perpetrators. So, an NDA is beyond the idea of we're not going to talk about this and the person got a settlement, so they're going to be fine. It extends fully into a person's entire life. Go ahead, Julie. So this is one survivor's testimony. I signed an NDA. I didn't know what the document was or what I was signing. I had no lawyer and was diagnosed with PTSD because of workplace sexual harassment, bullying, and rape. I was told I had to sign to get some money. And that is one thing that survivors speak about is they felt this pressure to sign an NDA in order for them to receive the settlement that they required in order for restitution and justice and to be able to move on with their lives. So, in some ways, it is presented that signing an NDA is closure, but what we'll find out is there is no closure with an NDA. So I'm going to talk about a few different psychological impacts of signing NDAs. There's the PTSD, or enduring traumatic stress response, the violence of silence. There is compounding trauma, including moral injury, institutional betrayal, secondary wounding, and systemic injustices. So go ahead, Julie. So we're going to first talk about PTSD. So PTSD is post-traumatic stress disorder. And if we break it down further, PTSD implies post. However, there is no post because NDAs do not permit disclosure. When you think about an initial event that is traumatic, so harassment, discrimination, um, physical abuse, sexual assault, any kind of specific incident that can cause PTSD, that is often one incident that remains in a person's memory that they can work towards overcoming and putting that behind them. With an NDA, there is no putting anything behind them because, as Julie spoke about earlier, it lasts forever. So it is a traumatic incident that lasts forever. It's not an incident, it's an ongoing process. So if we go back to breaking down PTSD, it also implies disorder. Well, yes, there is disorder, but it is actually a reasonable human response to intentional harm, silencing, victimization, betrayal. So it is not a mental health disorder. It is actually very, very, very human. So I've switched the terminology from PTSD to an enduring traumatic stress response, in that the events are continually relived, there is re traumatization, and there is a sense of very complex trauma. And so, all of these, if you look at the image on the right, if you look at all of these, then these never end for a person who has signed an NDA. They continually feel hypervigilant and re traumatized and continually self checking themselves. And there is not a sense of being able to effectively tell their story and have some closure. Go ahead, Julie. So, if we look at the compounding trauma of signing NDAs, if we look at the very bottom, there's the impact on the individual. So, this is all of the traumatic stress response from the initial incident, along with the ongoing not being able to tell, not being able to have closure, not being able to share their story and have things come to resolution. So, there's the impact on the individual. When an individual's life is so disrupted by ongoing trauma, there's clearly an impact on their relational functioning. Further beyond that, there's an impact on their occupational functioning. We move then into moral injury around the person's interaction with the world. There's secondary wounding, which is ongoing trauma and being involved in an ongoing process that has no resolution. There's a sense of institutional betrayal in that the people who are meant to look after us in our workplaces, in our religious organizations, everything moves into no place is safe. And then in the broader world, there's a sense of these systemic injustices that don't have resolution. And nothing changes until something changes. And that's our part in ending the misuse of NDAs, is being the role models in creating these systemic changes so that we can move forward as society. Go ahead, Julie. So NDAs maintain what is called the violence of silence. So they feed into cycles of violence where there's physical and psychological violence to the individual. So there's both the not changing things in the organization where the systemic abuse and harassment and discrimination is allowed to continue because of the violence. And there's also the violence of silence on the individual who cannot share their story and continues on in this cycle of institutionally perpetuated violence. There really is a sense of ongoing wounding from the requirement to self silence, self monitor, be hypervigilant. And there's a sense of isolation. There's being trapped in your own experience and not being able to share that and heal that with others. And as I showed previously, there's a sense of compounding trauma in every area of one's life. And I'll just share my own personal story here because it fits really well within the violence of silence. So My story is I was sexually I experienced clergy perpetrated sexual abuse when I was 12, and I kept that silent for most of my life. So there was tremendous psychological impact of that experience and the complex trauma of experiencing that. And when I did decide, and it was a complex decision-making process to disclose the historical abuse, disclose it to the police, disclose it to the archdiocese in which it occurred, I believed that that was going to be the opening to healing. And what actually happened was this being led through this legal process of victim blaming and shaming, which was completely re traumatizing. And when it came to the end of the process, I was terrified that I was going to have to sign an NDA and keep this entire experience silent for again for the rest of my life. So I reached out to Julie because I was researching how do I manage this? So I reached out to Julie through Can't Buy My Silence. And that's where she told me I can say no to an NDA and I can require the archdiocese to sign a one-sided confidentiality protection of privacy agreement where I was free to tell my story for my own healing, and they were required to keep all the information they'd garnered about me through this legal process. They were required to keep that confidential. And that was the moment where I started to feel like I had control over this process and could start to heal the trauma of everything I'd experienced. And that's how I came to work with Julie and Can't Buy My Silence. And this is what I want for every victim of harassment, discrimination, sexual assault, and we can move forward in the act of healing and social justice and restitution for these victims of crimes. Go ahead,
So
Julie.
just to add to that, I'm also a survivor of historic clerical abuse, and I first came across the whole idea of a non-disclosure agreement when I was negotiating with the church. In my case, it was the Anglican Church. And I think that, two things I want to really underscore from what Angela said that you should be clear about legally. The first, as she said, is you don't need to sign an NDA. It's often asserted that it's a required part of every settlement agreement. It is not. And we actually have case law saying very clearly that it's not. The only thing that's required in the settlement agreement is that I'm not going to continue to bring my case or my complaint. Obviously, that's the whole point of the settlement, but it doesn't require a non-disclosure agreement. And secondly, there are many areas of law in which we protect the identity of the victim. So, for example, when the Hockey Canada case came to trial, we didn't know the name of EM, but we knew the names of the defendants. We have similar processes that happen on a voluntary basis in civil court, where you can hide the name of a victim where it is something that they don't want everybody talking about, all this information about them, but you don't hide the name of the defendant. And that's been an accepted approach. So the idea now that you can only get your name hidden if you agree to hide the name of the other side is a whole new creation. It's an NDA, and that is not what the legal system traditionally does. There's no reason to say that you have to not speak about the other party to your family, to your friends, to your therapist, to your spiritual advisors. But there is good reason why you want to protect the name and identity of the victim. And that was exactly what Angela negotiated. And that's what we recommend that everybody does in place of using these toxic NDAs.
And that's what happened in my discussions with the archdiocese was being told, well, the other families don't want to come forward. Well, that is protection of the victim, and they have that choice. I, on the other hand, want the perpetrator's name shared because that feeds into the violence of silence if there is not that transparency and accountability. And so it's more than the victim, it's about the large organization. And that's the part that needs to be addressed with the signing of NDAs. There can be protection of the victim without protection of the perpetrator. Go ahead, Julie. So, moral injury stems from experiences that contradict an individual's sense of right and wrong, such as being a victim of or witness to acts that cause harm and the failure to protect others, or witnessing events that violate ethical standards. And it's more than witnessing, it's also experiencing them yourself. So, signing NDAs can lead to ongoing feelings of guilt, shame, betrayal, and ultimately a loss of faith in humanity. If victims are if victims experience ongoing oppression, ongoing silencing, it really makes no place safe. So these large organizations that are meant to be safe places for people become unsafe. And part of the moral injury is knowing that if nothing changes, then there are going to be further victims of the same harassment, discrimination, and potentially assault. So we need to change this. So, secondary wounding, and I kind of explained this a bit before. There's the initial incident that occurs, and the secondary wounding is often what occurs after a person discloses the initial harm. So, the secondary wounding is the process of bringing a complaint forward, and it's actually worse than the original experience itself. And I can attest to that in my experience. So I experienced the abuse when I was 12. I dealt with my life until, I was in my late 40s. And it was the 3-year process of bringing it forward where honestly I was treated like utter garbage. That was so traumatic and worse than the original experience that I'd lived my whole life with. And it was really like that's what brings me forward in doing this work is really wanting to prevent that secondary wounding and the re-traumatization to future victims and to any victims who've experienced this. So I can personally attest to the secondary wounding can worsen the traumatic stress responses and cause survivors to feel increased anger, guilt, shame, helplessness, hopelessness. It really is traumatic to go through an experience on your own when you're not able to talk to anybody else about it. And there can be damaging impacts with potential lifelong consequences spreading through many or most areas of an individual's life. I acknowledge my privilege and I acknowledge my education that has allowed me to get to this point in understanding what I was going through when I was going through it. And I know there are a lot of victims who do not have that capacity to educate themselves through what they're experiencing with the judicial process and with the impact of secondary wounding. So that's another reason that I'm working with Julie and Can't Buy My Silence because we need to create change to prevent the significant harm that happens to individuals and families. Go ahead, Julie. So there's a sense of institutional betrayal when a workplace, educational organization, large religious organization, when they fail to prevent or respond adequately to harm or abuse suffered by individuals dependent on that organization and that institution. There is a significant violation of trust. There is when there is a failure to act when there is a failure to investigate, a failure to provide support for victims, and also holding the perpetrator accountable. Now, I just want to talk about the support for victims. The abuser and organization that contributes to the abuse cannot be the place to provide the support for victims. That needs to be an outside organization, an arm's length away. Otherwise, if this organization is providing the support and yet is also the organization that betrayed the individual, there cannot be a sense of trust. So we really need to look at where is the best place for support for victims that is outside of the institution and organization. So, yes, there needs to be the investigation, holding the perpetrator accountable. But if there wasn't the safety for the victim in the first place, we really need to take a look at where is the best place for support for the victims. So we really need to look at what is the best place of action, accountability, and transparency for these processes. Go ahead, Julie. So these are some
So,
guiding principles moving forward. Did you want to take this part, Julie, or?
no, no, you go ahead.
Okay,
I think we
okay,
can do this a little bit together. So go right ahead.
sure. So the biggest thing we need to look at as employers, as organizations, as institutions is first do no harm. And now that you've heard this information from Julie and I, you know better. So now you have to do better. Um, Now you can recognize and understand the impacts beyond the individual, beyond the silence, beyond the, wiping our hands that this is over now, because it's not. We need to know the facts. And Julie's website, Can't Buy My Silence, is they are continually putting up new research, new information, and what the newest evidence-based best practices are. We need to focus on trustworthiness and transparency in truly being role models for change. We need to be able to provide victims with empowerment and choice in the victim leads the way moving forward, and recognize that everyone has a responsibility to amplify the issue, whether it's what Julie is doing in advocating for policy change, sharing best practice information, advocating for change, and even sharing Julie's website, Can't Buy My Silence, and telling people, take this training. This is the way to move forward. These are the ways that everyone can first do no harm and advocate for the change needed in ending the misuse of NDAs.
And just to add to that last point, we work with lots of different organizations, universities, churches, employers, unions. If you start working on this within your organization and you want to be connected with someone in an organization similar to yours who is also working on the same thing, please, please get in touch because we can almost always find somebody else who can discuss this with you, who will come from a similar perspective in terms of what your organization is doing. And I think that sharing that information is vitally important at the moment. I also think that it's important to recognize that change is coming. It takes a while to change the law, but we can see a very, very clear momentum here. We have 29 US states now who've passed laws restricting the use of NDAs. So at that point, employers, you don't have a choice any longer. You can't do it. These states include all political persuasions. So we have California that probably has the most expansive NDA restrictions law in the world, but we also now have Texas and Missouri and Tennessee. So there's a whole raft of different political compositions that are nonetheless enacting legislation because we believe firmly this is not a partisan issue, that this is an issue that affects everybody who cares about safety and families and freedom to speak. And we're seeing that reflected in the wide range of different states that are passing laws. We also have law in Ireland now. That was the first place that I worked with. That passed last year. The UK's legislation is hopefully coming to finality and royal assent at the end of this year, 2025. And Victoria, Australia, I've also been working there with the government, and they're also about to publish a bill. So I think we're going to see it pretty much everywhere in the next few years. It's just a matter of getting ready and how long it takes. And in Canada, just to give you a quick update, we have federal legislation that would cover federal government employees and anybody in a federally funded organization. So that would include Hockey Canada and CBC and others who we know prolifically use NDAs, but so does the federal government. And this would prevent them doing so. It would prevent public money being used to silence people about what happened to them. And while we only have provincial legislation so far in Prince Edward Island and in Ontario, where it restricts universities from using NDAs specifically, there are five other provinces where legislation has been tabled. Some of it is government, some of it is opposition. These are Manitoba, Saskatchewan, Nova Scotia, British Columbia, and New Brunswick. So you can see that this is happening all over and will only continue. So I really strongly recommend that you go back and look at your employment contracts, at your complaint process policies, at your letters of severance to see where you're using NDAs and non-disparagements. Think about taking them out and including perhaps a provision that a victim can always protect their own identity, but take them out so they're not there any longer and have at minimum a pilot period where you have no NDAs and see what happens. Because what we see over and over and over again, and there's research now in the US that's very clear on this, as well as what we know about what has happened since the legislation in PEI, nothing is going to happen. The sky will not fall. Those NDAs, they're going to be a thing of the past. You're not going to go on using them, and you're not going to see any real differences, except that the people who come with complaints are going to be enabled to come with complaints and not put off by the prospect of an NDA. And they're also not going to have to be angry about the fact that you're telling them they can't talk to anybody at all about what happened to them. It's only going to be good for your organization. And in the process, you are probably going to need to do some NDA education for your HR professionals, for your DEI folks, for your in-house counsel, and all of this we can help with if that's something that you would like us to do. We would
I
certainly
think
want your feedback, but we also would say that if you have questions or if you want an NDA informed training workshop for your particular organization tailored to your particular needs, then please get in touch and we would be happy to consider talk to you about doing something that would work for your particular group.
I think one of the things, just to reiterate what Julie is saying, is that it makes sense for trade secrets to have an NDA. It does not make sense for the human experiences of harassment, discrimination, and abuse to be kept silent.
So thank you for listening today, and please direct any feedback or any questions that you might have. And thank you.